Thank you, Chair. And welcome back, Judge Jackson. I know yesterday was a grueling day of questions, and I commend you for your poise, your endurance, your thoughtful answers. I felt privileged to be here for hours of that, and you had even more hours. But I want you to know the reaction in my own state of Vermont. I've gotten all kinds of emails and calls and from friends across the political spectrum. They're all been praising you. And they said they realized that a lot of the questions that were lobbed at you had nothing at all to do with your qualities as being on the Supreme Court, but were some members, unfortunately, aiming for what a soundbite that they might be able to put on a political website where it now is. For example, we heard some overheated claims yesterday that your representation on Guantanamo detainees somehow signaled your policy preference with how the United States has dealt with those detainees. Every single member of this committee, especially those of us who have been assigned as counsel in cases, should know better than to conflate a nominee's past representation with their policy positions, or to argue that a nominee espoused their client's viewpoint simply by choosing to represent them. So your policy views aside, can you reiterate why it's so important for our courts to have the benefit of the best possible legal representation on both sides of any case, and especially in cases where we are in uncharted legal and constitutional waters?
Yes, thank you, Senator. So I've been a judge for almost a decade, and what I've learned is that as part of my duty to render decisions consistent with my judicial oath in support of our Constitution and the rule of law, I need to consider all of the arguments related to the dispute that is being brought in my courtroom. I need to hear from not only the parties who are prosecuting a case, for example, a crime, but also from the defense. And some of these crimes are terrible crimes. Our Constitution is designed to ensure that the government affords due process to people who are being accused of crimes. And one might think it's even more important in a way in a case in which someone is so reviled. It's kind of like the First Amendment. It's a protection for unpopular views. It's needed when there's a chance that the government will suppress or do something that's untoward. And so in the criminal justice system, we have many, many amendments that are designed to make sure that unpopular people who are accused of doing terrible things, are still treated fairly by the government. And that's a limitation on government power, which is the framework of our Constitution. It is about limiting government overreach. And so in the criminal justice system, you can imagine, and the framers imagined, a world in which the government would use its authority to deprive people of their liberty, to throw people in jail, to lock them up and throw away the key, to not give people the opportunity to make arguments about their freedom. That would be a real exercise of government power, government overreach. And so the framers said, what we're going to do is we are going to put in our foundational documents a protection for people that the government is accusing of crime. And that's not to say that the people are innocent. That's not to say that they haven't done terrible things. What it's about is ensuring that the government does what is required in order to ensure all of our liberty. It protects all of us because there might be someone who is innocent, and if the government is able to just do whatever it wants in criminal process, we are all at risk.
Well, and I think we've all seen cases where that happened. I mentioned to you yesterday that I spent nearly a decade as a prosecutor. And especially when I had serious cases, I wanted the best defense attorney possible on the other side. I wanted a case that if I won, it usually went up on appeal automatically if it carried a heavy penalty. I wanted the court, the appellate court, to look at it and say, okay, there were not errors of counsel on either side. But I also, as a strong proponent of our Constitution, I think what you're saying is something I totally agree with. We have to have the individual's rights protected. It doesn't mean the defense counsel is in favor of murder or rape or armed robbery, but the rights have to be protected. And let me tell you about another area. I've authored and I've long championed the bipartisan John Lewis Voting Rights Advancement Act. I think it would help curtail the growing wave of voter suppression sweeping across our country. Again, something we don't have to worry about in Vermont, but unfortunately do in other states. I'm passionate about this legislation. I've always believed that our democracy is stronger when we expand, not shrink, the ranks of our citizens who fully participated. I believe our democracy goes stronger with your historic nomination and your presence before us today. And I've told you privately how my family members feel about that. Why is it important for our democracy's institutions, courts and all others, to reflect the rich diversity of our nation's citizenry?
Thank you, Senator. One of the things we've been talking about is the difference between the judicial branch and the other branches of government. We have three branches in our federal system, and the legislative branch has certain powers and it can do certain things to ensure that its prerogatives are achieved. And the executive branch has the power of might. The president controls the military. The judicial branch, its force in our system is the protection of the rule of law, which can only be done by essentially the consent of the governed. It can only be done if people in our society believe, decide, and agree that they're going to follow what it is that courts decide. And so one of the reasons why having a diverse judicial branch is important is because it lends and bolsters public confidence in our system. We have a diverse society in the United States. There are people from all over who come to this great nation and make their lives. And when people see that the judicial branch is comprised of a variety of people who have taken the oath to protect the Constitution and who are doing their best to interpret the laws consistent with that oath, it lends confidence that the rulings that the court is handing down are fair and just, that everything has been considered, that no one is being excluded because of a characteristic like race or gender or anything else. And that's important. I would also say that that it's important from the standpoint of role modeling. that I have been so touched by the numbers of people who've reached out to me in this period of time to say how much it has meant to their daughters, to their sons, to the next generation, that I've been appointed, to nominated and hopefully confirmed.
Well, I agree with you. I've certainly seen that within my own family. You know, we do have areas where we agree on things on this committee. Senators Grassley and Senator Cornyn, myself and others believe in transparency as part of our democracy. We've done this with the Freedom of Information Act when we've updated it a number of years. Senator Cornyn and I have been the key sponsors of legislation joined by Senator Grassley and Senator Durbin and others to improve the Freedom of Information Act. You've talked about the detailed opinions you've written to try to do the same thing. I think it's safe to say you believe transparency is central to the duties of a judge. Do you intend to carry that attitude and you will become a member of the U.S. Supreme Court?
Thank you, Senator. The value of public confidence, which I was just discussing, I think is enhanced when the public understands the reasons that a judge renders his or her ruling. One of my mentors used to say, people think the judicial branch is so secretive, but in fact, the judicial branch is the only branch that actually has to tell everyone, that actually has to write their opinions and explain why it is that they did what they did. And so I've tried in the nearly 10 years that I've been on the bench to make my rulings transparent, to explain all of the inputs that I have considered with respect to the case, to lay out the law as I see it in interpreting what Congress, for example, has done in with respect to a particular case, and what legal provisions that I think are relevant to the dispute, and then to explain my analysis. Why am I granting this motion or denying this claim? And my hope is that it will help people to be confident in my reasoning, and even if they disagree with it, they will understand what it is that I think, and I think that's important for public confidence in promoting the rule of law.
Well, you know, you had talked about your clerking for justice prior, how it opened up doors of opportunity. I remember so well our conversation in my office, in the President Pro Tem's office, talking before these hearings began. You told me what you thought it meant to your parents and your family, your husband, your daughters, your parents who have been here throughout this, and what it would have meant to your grandparents. You said you were the lucky first inheritor of Dr. King's civil rights legacy. I keep a daily journal. I wrote that down. It means a lot. So let me do this sort of an open-ended question. You've patiently answered our questions this week. I told you the reaction in Vermont was disappointment in some that were obviously political. I heard that from both Republicans and Democrats because they think it should be your legal thoughts in the Supreme Court. So I'd like to give you an opportunity to speak directly to the American people, including our little state of Vermont. Is there anything you want to convey to them about what kind of Supreme Court justice you would be if and when you're confirmed? It's all yours, Your Honor.
Thank you, Senator. Well, first, let me just address my comments to you in your office, which is something that I've said in speeches because it speaks to who I am and what I value. My parents grew up in Florida under lawful segregation. And what that means is that when they were coming through middle school and high school, they were not allowed to go to school with white students. This is in the era before and right after the Brown versus the Board decision. There was lawful segregation in places in this country. And it was after that time that Dr. King made his famous comments that people mention about having a dream where people can be judged by not by the color of their skin, but by the content of their character. And I then was born in 1970, and the contrast between my reality growing up in Florida and my parents' reality growing up in Florida, like night and day in terms of the opportunities that were available to me that weren't available to Judge Motley, who is one of my role models in the law. And so what my being here, I think, is about at some level is about the progress that we've made in this country in a very short period of time, I would say. It seems like a long time, but one generation, we've gone from the reality of my parents' upbringing to the reality of mine. And I do consider myself, having been born in 1970, to be the first generation to benefit from the civil rights movement, from the legacy of all of the work of so many people that went into changing the laws in this country so that people like me could have an opportunity to be sitting here before you today. What I would hope to bring to the Supreme Court is very similar to what 115 other justices have brought, which is their life experiences, their perspectives. And mine include being a trial judge, being an appellate judge, being a public defender, being a member of the Sentencing Commission, in addition to my being a Black woman, lucky inheritor of the civil rights dream. And in my capacity as a justice, I would do what I've done for the past decade, which is to rule from a position of neutrality, to look carefully at the facts and the circumstances of every case without any agendas, without any attempt to push the law in one direction or the other, to look only at the facts and the circumstances, interpreting the law consistent with the Constitution and precedents, and to render rulings that I believe and that I hope that people would have confidence in.
Thank you. And Chair Durbin, I've had the opportunity to be here. The first justice I got to vote on was John Paul Stevens, nominated by President Gerald Ford. Proud to vote for him. And it's a long arc, Judge Jackson, but I am so proud of your answers, and I appreciate it. Yield back.